thank the management body of this symposium who chose a very right topic at the right time, and also you gave me a very valuable opportunity to share some of my thoughts. I'm very thankful to all of you. I have tested the patience of the organizers because I've delayed in sending my topic, the abstract, the PPT everywhere. As you know, law people would be the most unruly and illegal. We know how to break the law properly. So I have done all those things with you, but you have shown your utmost patience. And I really, I'm thankful to all of you. To start with the presentation, my entire presentation I have designed in such a way that first I'll start with the technology and law, the interface, how lawyers and judges and the are using the technology over a period of time. There has been a paradigm shift we have observed, but still we are grappling with some problems, and we are still at the nascent stage in using the technology in administering the justice delivery system or in the administration of criminal justice or criminal courts or criminal practicing, or for that matter, civil courts and practice, mediation, arbitration, conciliation, various manifestations of justice delivery system. We are just started using this technology. Then comes artificial intelligence, how it is being used in some countries like Canada, but to what extent? Then how India has taken baby steps, and then what are the problems which we may surface if we use artificial intelligence in some of the walks of law, some of the walks of justice delivery system. And another question is it true that we can really artificial intelligence we can make, can it replace the human intervention? And even with this minimum intervention, what kind of repercussions we might have to face? This is how I have designed my entire presentation. And I can't see the audience now since I'm only looking at my presentation. I hope the audience are from engineering department, and do I do we have any audience from law schools or with law background also? Okay. Am I audible to all of you? Am I audible? Sir, am I audible?
Hello.
Am I audible, sir?
Yes, you are audible. So I was just trying to answer your question. Most of the students are from AI, artificial intelligence background, but we have law students also.
They have come from law school, sir.
Yeah. I see a student from the Rajiv Gandhi Law School at IIT Kharagpur. A student from OP Jindal.
Okay.
Are there any other law students? Yes.
Okay,
yeah. Sorry. And there is a student. What's her name? Bhargav. So there is Bhargav from your institute.
My NALSAR. Oh.
Yeah. Oh, and I believe some of them may also have joined online. So I have not looked into their background. But mostly this is AI, and this is what we have been trying to do. We are looking to have more participation from the law area also.
Okay, sir. Okay. I understand. Thank you so much for the feedback. Now, to start with, the technology is all laws are always 10 years old, and when we talk about IT and law, maybe we are like a century behind, because for a long period of time, the judiciary, the law practitioners were having a lot of aversion towards using the technology. So that is where the journey has actually started. Then slowly our judiciary, for example, has started, some of the judges who are very active, like Justice Madan Lokur. I gave this example earlier also in one of the symposiums held in IIIT. So he was sharing his experience with us one day at NALSA, that when he was the Chief Justice of Delhi High Court, he had to sentence an accused who committed a rape and murder of a 10-year-old minor girl. So it came he was at the stage of sentencing, and he did not know how much sentence he has to pronounce, and how to quantify it, or like whether the laws in India, most of them, they prescribe the maximum limit. It says up to 10 years rigorous imprisonment, up to life imprisonment. So we can stop anywhere, 1 year, 10 to 25. We can stop somewhere. But what are the parameters? The law doesn't guide the judges. This is the first problem he was sharing then on that in that program. Then what he did, he wanted to see what are the other courts doing, like Chhattisgarh, Andhra Pradesh, or Karnataka, Kerala. Across the high courts, he checked what is the general tendency or the trend which has been followed. Then he understood that 10-year-old girl, if she is raped, most of the high courts have given 12 years rigorous imprisonment. And if a 12-year-old minor girl was raped, they have given 10 years rigorous imprisonment. Like the age of the victim increases, the severity of the offense, it seems, they found that, or the judge's perspective is that the severity of punishment has to be reduced. So this is the use of having a database and showing the database to the judge appropriately could be the work of the artificial intelligence. But as of now, we don't even have databases on these kinds of parameters also. So minimum guidance also is not available to judges, he was wondering one day. So this is the one thing which IT and AI can help. This is how they can help in the administration of justice or justice delivery, I could say. Coming down to the technology and the electronic records and their admissibility in court of law, I have told you that the courts were having a lot of aversion towards this electronic documents. So they thought, the courts were of the view that this electronic evidence is very fragile, is prone to manipulation. So this can't be given the status of a conclusive evidence. So even today, let me tell you, all the students who are not from law background, let me tell you that this is given the status of corroborative evidence only. Corroborative evidence means supporting evidence, right? Now that too, a lot of discussion went on in the Supreme Court that with the electronic evidence, whether a certification also should be given, and who shall give the certification, any IT consultant or a certified examiner from Central Forensic Labs. That was one question. Apart from that, whether every electronic evidence has to be submitted along with a certificate. In 2020, in Arjun Pandit Rao's case, Supreme Court has said categorically that yes, every electronic evidence has to be submitted along with a certificate, which is under Section 65 B of Indian Evidence Act. So we are the judiciary, the lawyers or who are practitioners definitely are in they can utilize the services of IT and AI, and they can improvise the quality of their briefing, of their documentation. They can also need not waste much time in searching for the things if technology and AI is used properly. Coming down to our AI or artificial intelligence, now, it is time to turn to how AI is being used in law. At its heart, AI in law involves the application of computer and mathematical techniques to make law more understandable, manageable, useful, accessible or predictable. So, with that conception, one might trace the origins of similar ideas dating back to 16th century. Leibniz, the mathematician who famously co-invented calculus and was also trained as a lawyer and was one of the earliest to investigate how mathematical formalisms might improve the law. Artificial intelligence applied to law largely began focused upon knowledge representation and rules-based legal systems. Most of the research, it arose from university laboratories only, with much of the activity based in Europe. And in 1970s through 1990s, many of the earlier artificial intelligence and law projects focused upon formally modeling legal arguments in computer processable form and computationally modeling legislation and legal rules. I mean, in 1987, the International Conference of Artificial Intelligence and Law was held regular conferences showcasing these applications of artificial techniques to law. Pioneering researchers in this area of AI and law include Annie Gardner, McCarthy, Kevin Ashley, Winkels, Market Sergott, Richard Susskind, Henry Prakin, etc., etc. And an ideal domain, let me come down to this very important aspect of it. An ideal domain for a legal expert system project is narrow enough so that the task does not assume huge proportions while of sufficient complexity to present a challenge. So it is apparent that the process of modeling legal reasoning with computers gives to a very fundamental question. What is the nature of legal reasoning? It is normally not expected that a lawyer be able to explain the theory of legal reasoning underlying a legal opinion or judgment. Whilst perhaps somewhat unfair, it is certainly expected that the developers of a legal expert system should do so. A number of researchers have grappled with this question in the context of AI and law. And in particular, in my research, I found that Professor Joseph C. Smith at the UBC Faculty of Law has been very preeminent in this area, wherein he worked on theories about legal reasoning and judicial decision making range far and wide from theories of sheer anarchy and chaos to absolute predictable rule governed activity. So this points to fundamental difficulty in the field of AI and law. Like if lawyers and jurisprudentialists are unable to agree, this is the very important point which I want the engineers to look upon or think upon. Could be one of the limitations of the artificial intelligence as well. That if lawyers and jurisprudentialists are unable to agree upon the nature of legal reasoning, how may the process be modeled with a computer? So it is thus apparent that the building of a legal expert system is not only an exercise in computer programming, but also a venture into the jurisprudence. Moving ahead, the writing and production of a document, could be document drafting, which you can see there on the slide, is one of the areas where AI is at present used across the country. The writing and production of documents like preparing notices, these are all set formats where you don't want any big intelligent person to involve and think about, do interpretation and all. Friends, let me tell you, law is not a formula that you apply and you get a result. And let me also tell you that the facts of no two cases would be similar. You have crores and crores of cases, but the facts of no two cases would be similar. So you cannot apply a formula and arrive at a conclusion or a result. This is not possible with social science. This is not possible with the law. But so to a certain extent, with some limitations, I would say Definitely, artificial intelligence can help us. The writing and production of documents is a primary function of legal practice. Document drafting and assembly systems are essentially designed to automate the production of commonly used legal documents, which are tailored for particular parties and particular transactions. There is now a large number of commercial document drafting. Let me tell you, this is where it is being used by all law firms, even in India, and assembly packages on the market with very little, or I would say with very little standardization of methodologies. It is this area that would benefit greatly from some further research which might lead to the development of some de facto standards. So it is, however, worthy to note and often proven adage here. If it works, it isn't artificial intelligence. Further, it has been suggested that the term artificial intelligence lacks precise meaning also. These are some of the criticisms from the domain of law and justice. Moving ahead, document drafting and assembly systems generally fall into two categories. The first category consists of systems that do not have higher level intelligence built into the document production process. As I have explained, giving notice, filling a FIR form, or various kinds of miscellaneous applications filed in the court. These systems do not alter substantive sections of a document in response to user input. They are mainly used to produce multiple sets of documents, the text of which does not change materially other than for details such as, person's names, their date of birth, and other descriptions like their addresses and all. So this is one area where AI can really help the first category of cases. The second category consists of systems which make decisions about the content of substantive sections of documents, which subsection will apply. This all requires definitely the intervention of a human being, and artificial intelligence cannot really replace the second category of systems except for making some kind of adjustments or corrections relating to gender and grammar. Then comes this text analysis and retrieval system. It is in this area also that some of the most interesting artificial intelligence and law research is happening. Canadian lawyers, we have observed that they have a lot of familiarity with the legal text databases like Quick Law, Lexis, Westlaw. These databases share a common underlying query methodology, like Boolean search. At the most basic level, queries are constructed using the operators like and, or not. And Boolean searching has been criticized for the necessity for absolute precision in the formulation of the query and for its inability to retrieve conceptually as well as literally. So then if we move on with the document drafting and assembly and text retrieval, although very important, remain very peripheral to the primary function. This is what I want you to underline. These are all like, ancillary peripheral activities, but this is not the core business of law or justice delivery or justice administration. Coming down to India, what are the steps we have taken? The concept of artificial intelligence was introduced in the Indian judiciary by Honorable Chief Justice Ranjan Gogoi, through which the Supreme Court utilizes this technology to provide its judgments to the general public in several languages, Indian languages, through its AI tool called as SUVAS, S-U-V-A-S, SUVAS. The full form of it is Supreme Court Vidik Anuvad software. This is considered as a great achievement as far as the judiciary is concerned. They have taken the initiative. I hope I'm audible. If there is any issues with it, please tell me. Am I audible?
Yes, you are. please continue. So, I mean, we can take the questions at the end.
Okay, sir. Thank you so much. To understanding the artificial intelligence from the perspective or through the lens of lawyers, through the lens of prosecutors, through the lens of all the key role players of the justice administration, five attributes it might possess. The first one is communication, internal knowledge, external knowledge, goal-driven behavior, and the creativity. Artificial intelligence includes various types of learnings which the other technologies lack. These learnings are one is machine learning, cognitive computing, deep learning, predictive application, programming interfaces, natural language processing, image recognition, speech recognition, etc. And the process of every application of artificial intelligence is highly skilled and technical, and AI becomes the best because it acquires the qualities like knowledge, reasoning, problem solving, perception, learning, planning, and ability to move the objects. The first aspect of artificial intelligence is that it performs knowledge engineering by inputting tons of data, and it also helps understanding the relation of the object. It tries to understand the object. That is what gives the edge to artificial intelligence. This is one of the perspective of the lawyer. Then the nature of legal profession in India. In a legal profession, by and large, would be the same across the countries, but I'm focusing on the Indian perspective more. The nature of this profession in India is such that the entire process is done manually, and the senior advocates or the old generation lawyers are little redundant and reluctant towards the concept, as I've already told you. But AI is capable of playing a very big role, it seems, from by using all these technologies. And a string of Indian legal tech startups, and startups are there like Spot Draft, Case Mine, Near Law, and Practice League, etc. These are some of the startups which are building natural language processing based applications and introducing next generation legal research platforms. They are only working as of now as legal research platforms. Our law students make the best of use of them in doing their research projects, in doing the research for dissertations and PhDs, in also drafting the amendments for the existing laws and making new laws. And these next generation platforms, they're also helping law firms. They go beyond simple keyword based research, and thereby they make it makes less time consuming. Many legal startups are fast rising in AI research capabilities. Some of them have their own AI research labs also. But the question is, can a robo replace a lawyer? Can AI replace a lawyer? These are all some questions which are remaining unanswered. But the legal profession is highly driven by analysis. It is driven by decision making, research, and representation, which cannot be automated. Some areas of law, some areas of this domain, I think this robo or in artificial intelligence may not completely replace. This is my personal opinion. But it might impact at the same time, in the same breath, I would like to say that it might impact the law in few areas like due diligence. To review a contract, to conduct legal research, or performing electronic discovery functions to do due diligence, secondly, prediction technology. Artificial intelligence legal software also predicts the probable outcome of the cases being adjudicated before the court of law, and with that also reminds us about the next date of hearing. Then legal analytics. Artificial intelligence provides for the important points from precedents, reviewing the judgments and orders of the court given by other high courts and Supreme Court previously. And it might also impact law in the areas of automation of documentation, a very important area. By just submitting the required documents which you wish to incorporate in your legal document, you can get one easily drafts and incorporate changes in the documents, which you could be generated within minutes or seconds also sometimes. Then it might impact the area like intellectual property. Tools of AI help in providing the insights into IP portfolios, that is, search and registration of trademark, patents, copyrights, etc. The legal industry is still developing in India and looking forward to more AI-based and automated assisting softwares, which can be seen when the judges of the Supreme Court and the High Courts use e-courts. The cause lists of the cases which are listed the next day are mailed to the lawyers and the junior lawyers using iPads and tablets. This is the new scenario which we are observing in the High Court of Telangana recently. So there have been judges like Honorable Justice Sri Ranjan Gogoi inculcating the idea of Supreme Court that SUAS software, Vidik Anuvad software, which enables the judgments or orders to be translated into various languages. Actually, what happened, the language of the law is not understandable to a common man. Even an MTech student would find it difficult. They will say, what is this you are saying? Is it really English? They will ask many times. And so if it is translated into their language, maybe to an extent they will understand. This is how we are trying to bring awareness also, awareness of law to the common man, to the common man's doorstep. Now, moving ahead, challenges, what are the challenges which are, I'm trying to move the slide. Yeah. Which this artificial intelligence would pose to law. So one of the foremost concerns is of data protection. AI interface, I think the engineers would be knowing it very well that this relies on the data which is being fed to the software or the system. Secondly, there is no oversight to human being on the system and the decision is independently taken by the artificial intelligence. Then if the innocent suffers, who should be blamed? Like the data, when you are feeding it, it would be a data which is given by the authorities like the police department, the courts and whatever. Like, that data would say that, a particular parameter has to be considered while arresting. A particular parameter, like, a person belonging to a particular tribe, a scheduled caste, or a particular religion, if that data, like if there is a 10,000 criminals are there in a particular offense relating to theft, and 9,080 people belong to a particular race, religion, sex, and some place, AI would depend upon this data and would give you a conclusion or a hint, which could be a biased one. This is one of the very big criticisms which is posed against artificial intelligence. This is one thing. In India, on February 1st, 2018, Niti Aayog released the national program on probabilities of promoting AI in various sectors. In keeping with the objective of promoting AI, the government is set to support startups and centers of excellence with respect to artificial intelligence and research activities. However, AI is yet to have a guidepost, or how to be regulated or even be legally understood. These are some questions that are still unanswered. Like, what happens if we give citizenship to a robo like Sophia? Saudi Arabia awarded citizenship to a robo under the laws governing citizens. Will he or she be allowed to purchase property? Will that robo be permitted to drive a car? And if after permitting it to drive a car, if she or he commits a crime, what punishment would be awarded to her? Do we have a law to handle all these legal issues? Is it like the manufacturer, owner, or the robo only would be liable? These are all some unanswered questions I would like to think. Again, like, can a chatbot or a chat robo be liable if they commit some error with personalized data of a person? Then the data protection law nowadays, I know we are also coming out with the digital data protection bill, which would punish the people if it reveals. Then AI in the form of chatbots interacts with customers on different websites. These chatbots follow a scripted test to machine learning only, and increased interaction would enable them to deviate from the standard questions to provide a more human-like interface. In this course of communication with the chatbot, if a person reveals some sensitive personal information for some reasons, what happens to this data, which was fed by the computer or fed by the consumer or the client or the user? In case of a machine learning chatbot, which does not work as per scripted text and has collected some important personal information, who will be held responsible or who shall be held responsible? And if Rule 5.3 of the IT reasonable security processes, practices, and procedures and sensitive personal data or information rules 2011 is breached, the obvious answer would be the company shall be held responsible. Then the owner of the chatbot only has to be held responsible. But it is correct. Is it correct? The second most important question here is, what about the copyright law? Copyright be given to the AI or not? And if AI has started, in our, it is the part of our common knowledge now that artificial intelligence has started to create stuff like music, paintings, etc. Although eventually, if we analyze, does AI work on itself or the data fed by a human being? So should their work be considered as a copyright and can be called as intellectual property? This is another question relating to another domain of law. As per Indian Constitution, legal personhood has not been granted exclusively to humans only. Status of legal personality is granted to non-human entities like companies, corporate houses, and other legal persons also. However, this has been no case where a copyright has been given to a product or a thing made or produced by a machine. But as of now, it is given by to a human being only. But could it be given to a machine also? And what then another concern could be that AI has the ability to execute a contract. Hmm? But will the parties be bound by? Under Indian law, only a legal person is competent to enter a valid contract under Section 10 and 11 of Indian Contract Act. Now, 10 says what are the how an agreement has to be signed. 11 will tell us who is competent to enter into the contract. Now, are we giving that status also to a machine? And if that is the case, what about the justice? What is that punishment we are going to give to that robo, that particular machine which has entered into the contract? And what would be the locus standi? Locus standi is another big trouble for lawyers. This question would be better appreciated by students from law school. The most important and question raises here is that will be the nature of the liability when the AI commits a mistake, and will if that in that case, this concept of strict and absolute liability can be applied to AI. Because nowadays, if you see the legislations which are made in India, they all impose a strict liability. When this is for the for engineering students, I just want to tell you, take a minute and explain you. Strict liability is nothing but if a person is found with, for example, some ganja or some marijuana sort of a drug. No, or 20-gram drug is found in the bag of a person. He is arrested. NDPS Act, Narcotic Drugs and Psychotropic Substances Act, says that whoever is in possession, whoever hires, sells, exports, imports, is liable. Right? He is liable directly. whether you knew that unknowingly also you are carrying it, you are an innocent, someone might have dropped it into their bag. This is none of their botheration. This is called a strict liability, right? Now, increasingly, the governments, both the central government and state government, while enacting the law, they are imposing the strict liability. The question is, the same liability can also be extended to the machines of artificial intelligence is another question. This is the regular, I'm talking about the regular administration of justice. Then comes alternative dispute mechanisms which are there in this system, in this domain. That is arbitration, conciliation, mediation, and they are called as alternative methods of dispute resolution. So this dispute resolution machinery can be used to determine doubtful rights and obligations in expansive areas, including disagreements among corporate partners over profit distribution, like divorce proceedings, like criminal inquiries, etc., etc. Right? One of the primary characteristics of intelligent systems is the use of big data, something that is easily applicable to judicial decision-making processes also that require all-embracing record, keeping of the information produced during procedures to confirm legitimacy. So through this record keeping process is bungling and time consuming for law practitioners. To this extent, I think AI can be used. It is a good source of information for intelligent systems. This can be managed by the artificial intelligence systems. But as more data is fed, AI systems can provide relevant information for lawyers, judges, clients during the resolution of the disputes. This kind of a support system, I think the AI can provide to the law practitioners in this alternate dispute mechanisms. And case-based systems also can be developed, which can interpret and foresee the outcome of a dispute resolution process by comparing the information of a given case with the results of precedents within its database. Of course, database would be the substratum, the basic information which the AI has to process upon. On this data only it will process, but as you feed the system, the machine or the AI with more and more data, maybe the AI can come up with more and more qualitative decisions. The decision support systems can provide information like on the risks associated with the dispute resolution strategies. And say AI has the capability of a machine to reproduce intelligent human behavior. Hello, any question?
No,
I heard something.
no, no,
Okay,
no.
okay, no.
Please
Yeah.
continue.
Then another important area of the administration of justice is burden of proof. Please remember, the entire system, the courts work and they give results on the basis of the burden, on the evidence produced before the courts. So you have to weigh the evidence. You have to see how much truth is there in the evidence. That testing only would be happening in the court from the beginning till the end of the trial. That is that is the only job of the judge actually, to accept a proper evidence, to reject an improper evidence, and also to make the burden of proof, the standard of proof. In a criminal case, the standard of proof is beyond reasonable doubt. That means even a smallest doubt also should not exist as regards the guilt of the person. For example, at 10 o'clock in Triple IT on January 1st, a theft has happened. Okay. Now one X was found at about 9:45. Some people saw him in the same area. And that is an evidence, whether it is an evidence which has to be admissible or not. If it's a question, yes, admissible. But is it a conclusive proof that that particular ex committed the offense of theft? This has to be definitely done by the human intervention only. by applying many other things taken into consideration, AI won't be able to take a correct decision. Is the concern of the law practitioners and also the judges. Just to in detail, if I can explain the same, since the parties in a legal procedure usually will have opposing interests, the prosecutor will always oppose the bail. Accused will always want a bail. Accused will say, I have lot of problems, please grant me a bail. And the prosecutor will say nothing doing, he is a criminal, he has past criminal record. If you enlarge him on bail, he will definitely abscond this country and go to some other country, and thereby you can never complete the trial, right? Always parties will have opposing interests. So there is a danger in allowing the parties to establish the facts of a case amongst themselves, right? The opponent of the claim with which the dialogue begins has an interest in denying everything the proponent claims and in opposing every attempt to get her committed to anything. The law knows several means to limit the effects of such a destructive strategy. The first means is to have initial commitments for both parties to some facts that are assumed by default, for instance, facts that are generally known to obtain. Now, the burden of proof may be more or less severe, but it has 5 levels of support that can be given to a claim. One is scintilla of evidence. That is where there is at least one defensible argument for the claim that is admissible. Preponderance of evidence, where there is at least one defensible argument that weighs all arguments of the opponent for the opposite mechanism. You have both the parties have given their documents, and one document would outweigh all the rest of the documents in terms of its fairness, in terms of its truthfulness and correctness. This is another point or a fact relating to the proof. Then comes dialectical validity, where there is at least one credible defensible argument for the claim, and where all other arguments of the opponent for the opposite claim are defeated, completely defeated. The earlier one is preponderance of probability or preponderance of evidence is you have a better evidence. Here you have one evidence which can defeat all the other evidences. Now comes this beyond a reasonable doubt, where there is at least one strong defensible argument for the claim, where all arguments of the opponents for the opposite claims are defeated. So beyond a doubt, this is not beyond a reasonable doubt, but beyond a doubt. Where there is at least one valid defensible argument is there, all other arguments of the opponent for the opposite claim may be defeated. Okay. Under these circumstances, an argument is defensible, is defeated, is credible, is strong or valid, is defined on the basis of an underlying logical theory, for which I don't know whether AI can really give a replacement. These are some areas where human intervention, it seems, is completely required and nothing can replace them. AI is not, at least. This is one of the concerns of the law and the people who are into this domain. If the law is seen as having a rhetorical nature, the natural role for dialogical systems is that they support legal dialogues rather than evaluate them to their rationality. Systems that fulfill such a supporting role are called as mediating systems. In the recent literature on artificial intelligence and law, 3 such mediating systems have been proposed, which you can see there. One is Geno Argumentation Framework by Gordon. Another one is Room 5 Systems by Louis et al. And third one is Dialogue System by Lauder. So this Geno Argumentation Framework makes use of a discussion model that contains messages that are exchanged by the participants in a discussion. The contribution to the discussions can be given informally and are interpreted and formalized by a human mediator. The results of this interpretation and formalization are called marked messages. They are stored in the discussion model. content of the discussion model can be modeled as a dialectical graph. In such a graph, the positions of the different parties in the discussion and the support and attack relations between them are modeled in the form of a tree. The root of the tree represents the issue at stake, and the branches indicate lines of argumentation leading to different solutions for the same issue. This is the first one. The second one is room 5 system. It is similar to Zeno system in that it provides an environment for human beings to conduct structured legal discussions. Its logical support is somewhat lesser than Zeno, but this is compensated by a facility for retrieving federal decisions on past cases, or this is the third one, where the Zeno argumentation framework supports decision-making processes in general. Dialogue aims at characterizing legal justification. A legal solution for a case is justified if the parties in a legal dialogue reach to an agreement about the solution. This much we all of us know. The dialogue system supports legal dialogue by enforcing the dialogue protocol and by keeping track of the commitments of the parties in the dialogue. The dialogue system strongly improved an implemented version of the dialogical variant of reason-based logic that was proposed in Hague. As a consequence, it has reason-based logic also. And this logic, if it is not used, however, to evaluate the validity of arguments proposed by the dialogue parties, but rather to enable one party in a dialogue to force his opponent to accept what he was logically already committed to would be an issue. So these are the three things which I found out in my research, that these systems have been used in some of the countries and more particularly in US. And as a matter of conclusion, I can say that the artificial systems are not fully autonomous, but rather involve hybrids of computer and human decision making. A fully autonomous system is one that makes all important decisions about its own activity. By contrast, many leading AI systems are automatic to the extent that they are able, but then occasionally will defer important decisions to human beings. This system design is known as having a human in the loop. When a system has a human in the loop, the system does its best to perform autonomously in conditions where it is able to do so. But the system will defer to a human to make a difficult judgment or an assessment that remains outside the system's capability, or for which a computer decision is deemed socially inappropriate. And finally, there are few important contemporary issues in artificial intelligence and law which are worth highlighting. Although a fuller treatment is beyond, we cannot, it is not possible. One of the most important contemporary issues has to do with the potential for bias, which I have already raised this concern. If government officials are using, I again reiterate, because this is going to be major concern across the countries for people who are working into the justice administration. Like, if these government officials are using this machine learning systems or other AI models to make important decisions that affect people's lives or liberties, it is important to determine whether the underlying computer models are treating people fairly and equally. You have many kinds of discrimination. US has this whites and blacks. We have caste system here. Every country has some problem, some kind of discrimination would be definitely there. It is inherent in the system. And it is important, like whether the system has the ability and capability to treat all the citizens fairly and equally is the question. Multiple critics have raised this possibility that computer models that learn patterns from data may be subtly biased against certain groups based upon biases embedded in that data. I mean, this is the thing which I was raising earlier also. Another contemporary, like, police arrest records, if you see, imagine further that police activity in certain area is biased. For instance, perhaps the police tend to arrest certain ethnic community, minority groups. All this I have already explained. Another contemporary issue could be with the interpretability of AI systems and the transparency around how AI systems are making their decisions. Often, AI systems are designed in such a way that the underlying mechanism is not interpretable even by the programmers who created them. This is our understanding. I stand correct. You can correct. Various critics have raised the concerns that AI systems that engage in decision making should be explainable, interpretable, or at least they have to be transparent and fair. But some people also have advocated that the systems themselves be required to produce automated explanations as to why they came to the decision that they did. The final issue has to do with potential problems with deference to automated computerized decision making as AI becomes more ingrained in the government administration. This is the new threat which we are finding. Now, the goal, behind this area of artificial intelligence is to model the real world phenomena or processes in a form that computers can use typically for the purposes of automation. Often this involves programmers providing a computer with a series of rules that represent the underlying logic and knowledge of whatever activity the programmers are trying to model. Because the knowledge rules are deliberately presented in the language of the computer, this allows the computer to process them and deductively reason from them or about them. Knowledge representation has a long and distinguished history in the field of AI research and has contributed to many so-called expert systems. Then this is what I can conclude, that the AI, the artificial intelligence, has its own limits and limitations, but at the same time, it can also help in getting speedy justice, because this is one of the concerns of the justice delivery system in India, that we go to the court, generations pass by, but the victim is unable to get justice. So at least to this extent, I think artificial intelligence will help the law practitioners, the defense counsels, the prosecutors, and also the police, because police is one department which works with law without knowing law. They are not lawyers, they don't have law background, but unfortunately they have to implement the law. So this might help the police also in collecting the correct evidence, the appropriate evidence, and also in completing the investigation within the time frame given. I thank the organizers for giving me this opportunity. Now the floor is open for question answers.
Thank you, Professor Santhy, for the wonderful talk. Now it's time for QAs, questions. Okay, so I have a question, not on your talk, but for the future of artificial intelligence in law with regard to the state, colleges of law, like NALSAR. There are many, state universities of law. Like I know, WB, New Jersey is there. Here there is none, NALSAR, and I see, students coming from, these institutes, joining offline or online. But I'm curious to know whether there are any courses which can help purely the law students to get used to the AI technologies and get some idea about how AI can help them Has there been any initiative from the university level? Has this been, or has there been a talk to include anything as a part of the curriculum?
As of now, we are only dealing with, the mischief committed by technology, how to regulate it, which is taught in courses like cyber crimes, IT, and regulations and all. But how to promote artificial intelligence to improvise the quality of administration of justice, these courses could have been offered. Maybe some professors are offering it as a seminar course in some of the law schools. I'm not very sure.
Okay. So I mean, what are your, views about actually including the basics of artificial intelligence in the law institutes, so that so suppose I go to a seminar in law, so I can imagine what I will be going through. So I mean, after coming back, I would understand that possibly these are the areas where I can use my knowledge. I can use AI, right? Same would happen to the students purely from law without any background in AI. When they come to a forum where AI and law, AI along with law. So this we have been stressing. So AI, how AI can help in law. In order to understand that, so this is my belief that it has to come from the grassroots level. The students should have at least some idea from, basically the students from law should have some idea of what AI is capable of, what, which kind of problems can they offer to the artificial intelligence experts and hope for a solution. This is same for the field of AI. For example, the students who are interested in artificial intelligence and law, as a PhD students in AI, they also need to have some basic knowledge of law. Otherwise, they will not be able to apply artificial intelligence to law. So what are your thoughts? Like, what changes should happen at the national level in India?
Yeah. So we are trying to, this generation, unlike the previous ones, they are techno savvy. Our students, in all law schools, not only in NALSAR, they are using the technology. And as far as curriculum is concerned, we are also slowly introducing, these technical subjects, the interface in between technology and law, subjects like, and recently the UGC also has given a mandate to all the universities that cyber security has to be introduced as a mandatory subject for all undergraduates, graduates, and also postgraduates. Even Telangana government also, the Higher Education Council is preparing the draft for which NALSAR, is taking the initiative. We are preparing the drafts. So this is like slowly we are introducing the subjects which would deal with the interface in between technology and law. Yes, you are correct that it is going to be an inherent or inseparable part of the justice administration very soon. So it has to be taught as a mandatory subject at the level of BA. This undergraduate course itself we have to introduce. I do agree with you.
Thank you very much. Any more questions? Oh, I don't think so. So let's thank the speaker once again with a thundering round of applause. So thank you very much, Professor Santhy, for the wonderful talk.
Thank you, Professor, for giving me this wonderful opportunity.
Pleasure here.